August 2nd, 2026. That is the date half the internet treated like a master. Switch for the EU AI Act. If you ship software into Europe, or your outputs get used there, that headline is expensive to believe. It trains teams to prepare for the wrong cliff, and to miss the one that already started moving product code. Here is the clean verdict, then the mechanism underneath it. August 2nd was real. Transparency duties for many generative and chat products started applying. The European Commission's AI office could enforce rules on general-purpose foundation models with real fine power. National market surveillance authorities could police most of the other general AI rules already on the books. The heaviest high-risk system duties did not slam on the same morning. In July 2026, the EU passed the Digital Omnibus on AI, Regulation 2026-1744, signed July 8th, enforced July 27th. That package delayed the hardest high-risk loads. If your AI is used in hiring, workplace decisions, school admissions or scoring, biometric identification, critical infrastructure, law enforcement or migration control, the full high-risk system obligations wait until December 2nd, 2027. If you embed AI into regulated physical products, machinery, toys, lifts, and similar product safety categories, those duties wait until August 2nd, 2028. So the viral frame is backwards. August 2026 is not the day every European AI rule turned green at once. It is a responsibility pivot. Who owns which legal role? What proof can travel down the model supply chain? And whether your product can still show where an output came from after export, crop, and re-encode. That last question is the one most teams underprice. Europe does not regulate the job title AI developer. It regulates legal roles. A provider is usually the company that develops an AI system or a foundation model and puts it on the market or into service under its own name or trademark. A deployer is the organization that uses that system under its own authority, often an employer or a public body running the tool day to day. If a downstream company rebrands someone else's system, substantially rewrites it, or changes its intended purpose so the system becomes high risk, that downstream company can become a provider too. The test is concrete. Who places what on the EU market? Under whose brand? Who controls the product? Are the outputs used in the Union? Your LinkedIn title answers none of those. So what does that mean if you actually ship? Calling an API from OpenAI, Anthropic, Google, or Mistral does not automatically make your startup the foundation model provider for that lab's training data paperwork. But if you ship a chat agent, a hiring screener, a content generator, or a decision product under your own brand, you are usually still the provider of that product layer, the AI system wrapped around the model. A company that only uses a finished third-party tool inside its own walls is, more often, a deployer. Deployers still face duties, staff AI literacy measures, deep fake disclosures when they publish fakes, emotion recognition notices when those systems run, and later high-risk deployment duties when the facts fit. Contracts, brand, control, intended purpose, and how deep you modified the model decide the case. There is no, we just call an API escape hatch. Now the transparency trap. The piece product posts simplify into add an AI label. The transparency rules, often discussed under Article 50, do not stamp AI generated on every machine-assisted paragraph. On the provider side, the company that puts the generating product on the market, systems that produce synthetic text, images, audio, or video should mark those outputs so machines can detect the origin within technical feasibility. If your product talks directly to a person, you should tell that person they are interacting with AI, unless any reasonably careful user would already find that obvious. On the deployer side, the organization using the system, the duties track the use. Emotion recognition or biometric categorization, notify the people affected. Publish a deepfake, Disclose that the media was artificially generated or manipulated. Publish AI written text meant to inform the public on public interest topics. Disclose the AI origin, unless a real human editor reviewed it, controlled the edit, and a named person or company takes editorial responsibility. Light assistive editing can fall outside machine-readable marking. Content created before August 2nd, 2026 does not need a retroactive stamp. That only holds if you separate two different jobs. A newsroom with a real editor who rewrites the draft and accepts liability is not the same case as an unattended bot auto-posting public affairs text. A static footer that says "powered by AI" is not machine-readable provenance that survives a screenshot, a re-encode, a copy-paste, or a CDN rewrite. If your pipeline generates an image, then upscales it, crops it, compresses it, and ships it through a third-party CDN, someone on your team has to know which hop can kill the mark, and which generation event, model version, and publish event still chain together. That is product architecture. That is not legal copy. Here is the part foundation model buyers keep missing. Rules for general-purpose models mostly existed before August 2026. The date mainly made them enforceable. Those model rules, often discussed under Article 53, already asked model providers to keep technical documentation on training, testing, and evaluation to give downstream product companies enough information to understand capabilities and limits, to run a copyright compliance policy that respects text and data mining rights reservations, and to publish a training content summary detailed enough for the AI Office template. Models the EU treats as systemic risk face more. One presumption threshold is training compute above 10 to the 25 floating point operations. Frontier-scale compute, not a laptop fine-tune. The Commission can also designate models by capability and scale without that line. Extra duties include evaluation, adversarial testing, systemic risk mitigation, serious incident reporting, and cybersecurity measures. From August 2026, the Commission can fine a general-purpose model provider for intentional or negligent breaches, refused information, false or misleading answers, blocked assessment access, or ignored remediation. The ceiling is the hire of 3% of worldwide annual turnover, or €15 million. That is a maximum, not an automatic ticket for every missing footnote. Proportionality still matters, but the model card written for researchers is now a compliance interface in the supply chain. The number that makes this commercial is simple. A model that scores well on benchmarks but cannot hand versioned limits, evaluation digests, copyright and training summaries, and change notices to a downstream product company can still fail enterprise risk review. Throughput still sells. Evidence that travels sells now too. Sitting in that gap is the general-purpose AI Code of Practice. The Commission and the AI Board treated it as an adequate voluntary proof path. Amazon, Anthropic, Google, IBM, Microsoft, Mistral, OpenAI and others signed. Meta publicly refused and called it overreach. Signing is not a free legal pass. Refusing is not automatic non-compliance. A non-signer can still prove alternative adequate means, usually under more questioning. If you release weights, the open source story is sharper than open community free pass. To touch the open source relief for general purpose models, a license generally needs to allow access, use, modification, and distribution with weights, architecture, and usage information disclosed. Even then, relief mainly cuts parts of the technical and downstream documentation. Copyright policy still applies. The public training summary still applies. Systemic risk models get no open source holiday. Open weights, source available, and free and open source under the Act are not the same thing. Use bans, redistribution locks, or paywalled platform monetization beyond security, and interoperability can push a release out. A free GitHub or Hugging Face download is not the whole test. Fine-tuners get a different cut. Ordinary LoRa adapters, quantization, and light modification usually do. Not mint a brand new foundation model provider. Commission guidance points that way, with an indicative signal around 1/3 of original training compute before a modification starts, to look like a new model. Guidance, not a hard safe harbor. You can still become the provider of the product you ship. Fine-tune an open language model into a candidate ranking tool for recruiters, and you may escape the original lab's full training data dossier. You can still face system-level risk management, data governance, human oversight, and conformity work when the high-risk hiring rules apply, which brings the expensive half of the calendar. Official materials delayed those high-stakes system rules: hiring, education, biometrics, critical infrastructure, law enforcement, migration, and regulated physical products, because standards, common specifications, guidance, and national supervisor capacity were not ready. That lowers near-term certification panic. It is not a permission slip to freeze bad architecture. You still decide early what the product is for, where training and test data came from, what you log, how a human oversees the system, and what vendor contracts demand. Marketing claims and real customer use together decide whether you later fall into those high-stakes categories. Redesigning after your product is wired into HR workflows, or school systems is the expensive move. Who feels August 2026 without the jargon fog? If you train a new foundation model and offer it into the EU, documentation, downstream disclosures, copyright policy, training summary, plus systemic risk extras if designated, commission requests and fines are live. If you ship SaaS or agents on someone else's API, you are usually not the owner of the upstream training file. You still need capability and limit information from vendors. Your chat UI may need an "you are talking to AI" notice. Your generation pipeline may need machine-readable marks. Multi-model routing makes this harder. Retrieval, main model, rewrite, image, human approval. Logging only the final vendor name will not rebuild provenance later. If your company only uses finished tools internally, you are mostly a deployer. Literacy measures still exist. National supervisors start policing from August 2026. The law does not require every company to invent a job title called AI officer. If you ship deepfakes, virtual humans, synthetic voices, or image generators, provider marking and deployer disclosure can both apply. Artistic and satirical uses can disclose without wrecking the work. They do not get a total free pass. The hard problem is whether the mark survives export. If you are outside the EU, placing a model or system on the EU market, or having outputs used inside the Union, can still pull you in. Servers outside Europe is not a reliable exit. Non-EU foundation model providers generally need an authorized representative, with limited open-source exceptions. The strategy that survives is not a thicker PDF of legal bullets. It is 3 engineering capabilities: role and version traceability, for each component, who is provider and who is deployer, under which brand, at which model and system version, for which intended purpose. Upstream evidence that can travel, limits, evaluations, copyright and training summaries, change notices you can hand to a customer or auditor without inventing them, under deadline. Durable output provenance, origin signals born at generation time that still mean something after edit and distribution, plus event links between generate, approve, and publish. 2 limits, said plainly. Machine-readable marks are not truth certificates. A watermark claims origin. It does not prove facts true, and a missing mark does not prove a human wrote the piece. Malicious actors will strip what they can, and member state consistency on obvious AI chat, appropriate disclosure, and first penalties is still untested. Model-level enforcement sits more with the AI office. Transparency fights will feel national first. Watch the first AI office information requests to model providers. Watch the first national transparency investigations. Watch how code signers and non-signers prove compliance differently. Watch the first training summaries rejected as too thin. Watch whether technical standards arrive before the December 2027 high-risk cliff for hiring, education, biometrics, and the rest. Those events decide whether the Act becomes a reusable product governance interface, or a cost that scales mainly with company size, and which capital city you argue in. August 2nd, 2026 did not finish the EU AI Act. It started the phase where labels, model cards, and footer disclaimers stop being enough, and roles, evidence, and provenance become product features.